I request the appellant, Team 12, to come forward and present their argument.
One thing can we do it? Instead of wasting your time in telling the facts now, it will save your time and you will be. So then cut short the facts, because we have to assess your knowledge of facts also. Don't waste more time on that so that you can express your legal views for more time. Team 12. No?
The Council seeks permission to address the bench collectively with utmost respect, as your Lordship, and with due respect to my lady. Much obliged. Your Lordship, with due respect, this is Council 2 appearing on behalf of the appellant before this Honorable High Court, and with your permission, I will be dealing with the starting two issues. If the Honorable Bench is well versed with the facts of the case, the Council respectfully seeks permission to go ahead.
Summarize your
Summarize.
facts, because we have to assess on the facts also.
Your Lordship, the facts of the cases, as Rojesh and Ria met at a social event and Rojesh offered job to her which she accepted. Over several months, their personal relationship grew and they started living together. They also jointly purchased a house in Rojesh's name and shared loan repayments. In December, Rojesh proposed to Ms. Ria and promising marriage by the end of 2024. But by mid-2024, Rojesh became distant and avoided discussions about the marriage. But he surely committed to his commitments. On June 2nd, 2024, he withdrew the wedding savings and later transferred the funds to the joint account with another woman, Maya, who is a startup funder. In July 2024, during a trip to Nag City, Rojesh decided to end things, and Ria later discovered that Rojesh had also sold their jointly purchased house and transferred the proceeds to his account. Feeling betrayed, Ms. Ria filed an FIR on August 1, 2024, alleging rape, domestic violence, and false promise of marriage. And he was tortured in custody to extract a confession, and the police remand was repeatedly extended beyond the statutory limit. When summoned to court, Rojesh failed to appear, leading to him being declared a proclaimed offender. In 2025 February, he was convicted in absentia and sentenced to life imprisonment by the Sessions Court. Rojesh, through his legal counsel, has filed an appeal before this Honorable High Court, challenging the trial, the handling of the remand proceedings. Your Lordship, with your permission, for the convenience of the proceedings, the Council humbly requests to present the timeline sheets of the events for the convenience of the case. Much obliged, Your Lordship.
23. So
With due respect, the Council seeks permission to go ahead with the contentions. Much obliged, Your Lordship. As the issue number 1 is concerned, whether the appeal is maintainable before the High Court, it is most humbly and respectfully submitted to the Honorable High Court that the appeal is maintainable before the Honorable High Court under Section 415 Clause 2, Subsection 2 of INSS, where it is stated that any person convicted on a trial held by session judge or an additional session judge or on a trial held by any other court in which a sentence of imprisonment for more than 7 years has been passed against him, he may appeal to the High Court. This is a crucial safeguard against judicial errors, ensuring that the accused is given an opportunity to challenge the conviction. Your Lordship, on the page number 9, taking the precedent in Muhammad Sukur Ali versus State of Assam 2011, the Honorable Supreme Court ruled that the right to appeal is an essential safeguard against a wrongful conviction. And taking another precedent in the case of Tara Singh versus State 1951 on page 9, it was established that procedural lapses affecting fair trial rights provide grounds for appeal. Despite being on bail, he was convicted, the appellant, in absentia without proper compliance with BNSS under Section 356 and declared as proclaimed offender, which is unjust and therefore making grounds for the appeal. Taking another precedent on page 10, in Zahira Habibullah Sheikh versus State of Gujarat 2004, where it was held that failure to ensure a fair trial violates fundamental rights, making appeal necessary. As the trial in absentia, Your Lordship, with due respect, conducted against Mr. Rojesh violated essential due process principles of the Constitution and procedural law. A conviction in absentia should be the exception rather than the norm, and strictly adhering to the procedural safeguards to ensure the fairness. Your Lordship, the respective counsel of respondent has said in their statement of jurisdiction in their memo that the appeal is not maintainable till Mr. Rojish is present before the Honorable High Court and that he is still absconding. But Your Lordship, the respected respondent in very first line of their summary of arguments on page number 11 has said in their very starting lines of summary of argument that appeal is maintainable. And so on, we don't think that their question arises from their side, as their own has mentioned in their summary of arguments in very first lines. Your Lordship, with due respect, the counsel humbly submits that regarding their statement of jurisdiction, that nowhere in the facts it is given that Mr. Rojas is still absconding and he is still not there. As in any case or appeal, the case and appeal is filed through the legal counsel, but that doesn't mean that Mr. Rojish is still not there. And therefore, Your Lordship, the counsel humbly submits that appellant is always ready to present before the Honorable High Court if the Honorable High Court, if protection is assured to him, as first of all, first-handedly in police custody, he was tortured and therefore he has the fear. So, of course, the appellant, Mr. Rojish, is surely presentable in the High Court, but if he is assured that the protections will be given to him, as the harassment of the police has happened regarding him, and he has already faced a lot of torture on the hands of the police, and therefore the appeal is maintainable before the Honorable High Court. If there are no more other queries, the counsel humbly requests to go ahead with issue number 2. Much obliged, Your Honor. As the issue number 2 is regarding that whether the trial in absentia adhere to due process, the counsel for appellant most humbly and respectfully submitted to the Honorable High Court that the trial in absentia was not conducted adhering to due processes. The trial of the appellant, which was conducted in absentia, violated fundamental principles of due process guaranteed under the Constitution of Indus Land. The conviction based on such a flawed trial is unsustainable in law. As per taking the precedent on page number 11 of appellant memo, in the case of Menka Gandhi versus Union of India 1978, it was held that the procedure laws affecting personal liberty must be fair, just and reasonable. In the current case, Your Lordship, with due respect, the improper proclamation led to unfair trial, violating the fundamental rights of the principle, and the counsel most humbly submits that under section 356 of INSS, the condition is issuance of 2 consecutive warrants must be there at least in interval of 30 days. And the respondent on their memo has indeed mentioned that the consecutive 2 warrants was given. Indeed, the appellant also agreed that consecutive 2 warrants was there, but the issuance of 2 consecutive warrants was not within the interval of 30 days, as the timeline is present, Your Honor, on your sheets. The first warrant was issued on 1st of December 2024, and soon after the second consecutive warrant was issued on 28th December 2024, which does not fall under this section and violates this section that 30 days of interval period was not at all followed. And also the appellant humbly submits that Rojish was convicted in absentia, which was not a fair trial. Under section 356 of INSS, court shall not commence a trial unless a period of 90 days has lapsed from date of filing the charge sheet. Your Lordship, in the given timelines of periods, we have mentioned that the trial period was not commenced after 90 days, as the timeline was not lapsed, as the charge sheet were filed at the end of November, but the case was committed in trial in absentia, which was February 2024, and the exact date is not given. But if we presume that from end of November to February, the 90 days of period does not lapse, and therefore this whole trial in absentia was unlawful, and therefore the appellant most humbly submits that this trial in absentia was not regarding the due process. Your Lordship, with this I would like to submit the contentions.
You agree that you were under police custody. You have admitted that you were there for more than 90 days and you were released on a default bail. You are agree that you are knowing that the one or the other day the charge sheet would also be filed. When you were released on a default bail, it is a mandatory that you should take care that whenever the charge sheet is filed, whenever the summon comes, it's your moral duty that you should be there. You are taking benefits that this provision has not followed, that provision has not followed. What procedure you have followed?
Indeed, your lordship, the council first of all submits that the appellant was first of all scared as he was continuously harassed in whole custody of 90 days, and therefore he wasn't absconding but he was saving for his life, that he should be appealing or presenting before the honorable court on the future dates, as he was still overcoming from that harassment which he has been provoked with, and therefore he was he was still saving his life.
So now you do not have a threat to your life?
Indeed, Your Honor, we do have. It took time for the council to come over his harassments, to come over his fears, and the council for the appellant humbly submits that he do wants the justice to happen, and therefore the council has been submitted to the Honorable High Court.
Yeah.
Whether this appeal is maintainable.
Indeed, Your Lordship, under section 415 subsection 2 of INSS, it is said that.
Come to point number 23 of the problem.
Page number.
This appeal is presented through advocate. Last point of the problem.
Yes, Your Honor.
Now come to subsection 7 of 356. Section 356 BNSS subsection 7.
Indeed, Your Lordship.
How your appeal is maintainable? You are not personally present before the court and you are presenting the appeal through advocate.
Your Lordship, it is indeed it is submitted honorably and respectfully that the council submits that the appellant is ready to present before the honorable court if he is ensured that the whole harassment which happened in custody with him will not be happened, and if he is regarding given the assurance and the safety regards, he is surely able to come in front of the Honorable High Court.
Where is question of custody and custodial torture? Where is question of harassment?
It is mentioned in the facts, Your Honor.
Law prescribes that appellant should be present before the court, not before the police. Court is not going to torture anybody.
No, not at all, Your Lordship.
Then, had it been a case that he was bound to submit before the police, then there was a question of harassment and cruelty in the jail. But when he was asked to surrender before the court, he to remain present before the court, then there is question of harassment.
Indeed, Your Lordship, but as the appeal has been filed with regarding to the council, it is not mentioned that he is not present in the court. Like in the facts, it is nowhere to be mentioned that Rohit.
You have to justify that. The facts are narrated in such a way that you should be in a position to answer those things. Why these questions has been raised that whether appeal is maintainable. So you have to justify that. You are not there before court. The appeal is filed by the advocate. How you justify it? Through advocate.
Indeed, Your Lordship, but as in criminal appeals or the cases, it is not always be in regarding to the facts and provisions that always the appellant has to be presented, and therefore he has been filed through the council, and the council is submitting the contentions.
Respected sir has specifically asked you whether appeal is maintainable in the absence of your appellant.
Indeed, Your Lordship, the appeal is indeed maintainable before the Honorable High Court.
Yeah.
With this, the council would like to submit the contention.
Yes.
This was council 2 on behalf of the appellant. It was the council 2 is grateful for the Honorable High Court's time, valuable time, and the rest of the issues will be dealt by council 1.
Your Lordship, I, Counsel number 1, with your permission shall begin with the further contentions. Much obliged, Your Lordship. Issue number 3. Was the lower court's application of substantive and procedural law appropriate? Your Lordship, on page number 13 from the appellant's memorial, in the Uday versus State of Karnataka, the Honorable Supreme Court of India emphasized that a mere breach of promise to marry cannot be equated with consent obtained under false pretense. There is no evidence that shows that Rojesh did not intend to marry Ria, and The charge of rape under section 375 read with section 376 of IPC requires proof that the sexual act was committed without the consent of the woman or the consent was obtained under the false pretense. Ria's consent in this case was obtained on a genuine promise of marriage, and the subsequent breakdown of the relationship does not automatically invalidate that consent. Your Lordship, it is crucial to differentiate between a false promise and a breach of promise. A breach of promise is when the person genuinely intended to fulfill the promise, but due to certain circumstances he was not able to fulfill. But on the other hand, the false promise means that the person from the start itself intended to deceive the other party. And in this case, Your Lordship, no such distinction was made. Evidence suggests that Rojesh initially intended to marry Ria, but the changes in his intention does not justify the charge of rape. Your Lordship, on page number 14 from the Appellant's Memorial, the Honorable Supreme Court in CBI versus Anupam J. Kulkarni laid down the strict guidelines regarding police remand and emphasizing that it should be sparingly used and only when necessary to gather crucial evidences. Your Lordship, but in this case, no such guidelines were followed. The police abused the powers by repeatedly seeking extension remand without providing valid reasons, and this proved that the investigation was not being conducted in a fair and impartial manner. The police failure to file the charge sheet within the prescribed time led Rojesh being granted the default bail. This indicates a serious lapse in the investigation and failure to comply with the mandatory provisions in the INSS. The trial in absentia, Your Lordship, without ensuring that appellant had the knowledge of the proceedings and a reasonable opportunity to defend himself, also violated his fundamental right. And with due respect, it is humbly submitted before this honorable court that the application of law by the lower courts were inappropriate. With your permission, Your Lordship, I shall continue with the further contentions.
One question. Suppose procedure provided under section 84 of the BNSS, which was 82 in CRPC, custody beyond limit, is not followed. Does it vitiate the entire trial when there is evidence against the accused that he has committed this or
Your Lordship, indeed,
that may be a separate cause of action? If you are detained in the custody for more than 15 days in police custody and 90 days you were in custody, that for that you may file a suit for compensation, you may sue the government for compensation. But on that aspect, how you can challenge your conviction, how that conviction will and trial will vitiate?
Your Lordship, actually at the first place, the charge of rape that has been applied on the Rojesh does not fall under the definition on which the charge sheet has been filed under section 375, read with 376 of the INSS, and the consent was, it was consensual act, so the charges are not applied. Therefore, the further proceeds, whatever the procedures were followed does not come into the question because he was not the accused actually.
How you can infer your intention?
Sorry?
You said that it was consensual sex and there was no intention to cheat. That is one aspect.
Indeed, Your Honor.
But
Actually,
looking to the facts of the case, we can infer that there was intention to cheat because you have taken away the amount which was deposited by Ria. First thing. Secondly, you have sold out the house which was purchased from her income also. And not only this, you have deposited that amount in the account of Maya, who is your fiancé.
indeed, Your Lordship, the facts have stated this, but Your Lordship, in the initial days, Rojesh's cohabitation with Ria and they both mutually purchased the house. These are the evidences that initially he intended to marry and also was in good terms with Ria. But due to the changing times and the pressure from his parents to marry some other girls because and the deteriorating relationship of both of them, time changes and a relationship gone sour cannot be treated as a criminal act, Your Lordship. With time being, the relationship can come on bad terms.
Then you must have refunded the amount to Ria if your intention was so good.
it may be possible that Rojesh could have communicated to Ria, but immediately after the selling of the house, she immediately filed the FIR without wasting a minute. She could have filed the FIR when he ended the relationship, but she was not concerned about the marriage. She was concerned about the house that was sold. So immediately after selling of the house, she went and filed the FIR because she was frustrated and wanted to take revenge from Rojesh.
Yes.
Issue number 4. Was the charge of rape correctly applied? Your Lordship, on page number 15, in Dr. Dhruvara Muralidhar Sonar versus the State of Maharashtra, the Honorable Supreme Court held that if a promise of marriage was bona fide, there was a genuine intention to carry it out, the subsequent failure to marriage does not automatically render the consent invalid. Your Lordship, a relationship consort cannot be treated as a criminal act. Rojesh initially intended to marry Ria, but due to changing circumstances, he was not able to marry her. Your Lordship, initially the arrest was made under section 69 of BNSS, which prescribed the punishment of not exceeding 10 years and fine. But later the charge sheet was filed under section 375, read with section 376 of IPC, which prescribes the punishment of not less than 7 years and can be extended up to the life imprisonment. There is a drastic difference between the punishment, Your Lordship, and it is possible that the police had some personal grudges with Rojesh, and a very serious question arises here, that how can the final charge sheet be filed in very few days, that is 10 to 15 days, where the same investigation could not be taken place when he was in remand for the 3 months, and the same investigation was completed in this short period of 10 to 15 days. And also, Your Lordship, the external pressure from his parents and also the deteriorating relationship with Ria forced him to take the decision. Your Lordship, the council requests this Honorable High Court to set aside conviction and acquit him of rape charges.
We have been directed that if you exceed your time, the negative mark should be given. So the participant, please restrain yourself.
Your Lordship,
Conclude yourself in 1 minute.
thank you, Your Lordship. Your Lordship, issue number 5 was the repeated extension of police remand lawful considering constitutional protections. The Indusland Constitution, that the Indian counterpart guarantees fundamental right, including the right to personal liberty, and prohibits unlawful detention. Your Lordship, in CBI versus Anupam Kulkarni, the Honorable Supreme Court emphasized that the police remand should be an exception, not the rule, and should only be granted when there is a clear need for the custodial interrogation. Your Lordship, the police merely stated that more time is needed without any proper justification that why the time was needed, and the police extended the remand again and again from 16th August, which was granted again till the 14th of November. Your Lordship, here the first remand to be noted was granted from 16th August to 30 August, and Your Lordship, according to the law, the application for extending the remand should be filled before the expiration of the previous one, but it was presented on 1st September, where the previous remand already expired on 30th August itself. Rojesh was subjected to illegal detention again and again, which violated his fundamental rights. And also under Article 22, Clause 2, the Indian Constitution, it is clearly mentioned that every person who is arrested should be detained and detained in the custody shall be produced before the nearest magistrate between the 24 hours of such arrest. But in this case, Your Lordship, the accused was arrested on 14th August and produced before the local magistrate on 16th August 2024's evening, which is a grave violation of his fundamental rights. The Council respectfully submits that the repeated extension of police remand in this case were unlawful and violated the constitutional rights.
You are referring the judgment of Anupam Kulkarni. Okay. It is of 1992. In 2023, there is judgment of Supreme Court in case of CBI versus Vikash Mishra, wherein contrary view is taken by the Supreme Court, and Supreme Court has held that there can be police custody remand for more than 15 days. And now the issue is referred to the full bench in case of V. Senthil versus V. Balaji Senthil. So in the teeth of the subsequent judgment of 2023, your first argument relying on the case of Anupam Kulkarni's case, that will not appeal to the court.
Indeed, Your Lordship, but
Because we
the,
have to follow the recent judgment.
indeed,
and-
Your Lordship, but the extension of the remands were unlawful because it is to be, the application is to be filed before the expiration of the previous one.
Then again, the first question I asked to first counsel, that whether such extensive remand vitiate the entire trial.
Indeed, Your Lordship,
How?
because the procedures were not followed according to the
Okay, he was
procedures.
illegally detained. Take a case, admit that it was illegal detention. What is the remedy for that?
The
Can you
fundamental
set free from all the charges leveled against you and proved against you?
no,
Only remedy for you to seek compensation.
no,
or
Your
the-
Lordship.
Or sue the respondent subsequently when if you get acquittal.
Your Lordship, the whole case is not just about the accused, the conviction of the accused, but also the procedural laws that were violated during the procedure, and the police and the state did not follow the procedural law. The case is also about that.
We have to see that procedural law is handmaid of justice. It cannot prevail over the substantive law. There may be some procedural lacunas. If procedural lacuna is not going to affect the entire trial, why should we believe that only because procedural aspects were not followed, entire trial is illegal?
Because, Your Lordship, the fundamental rights of the accused were also violated, and it goes beyond the nature of justice. So that is why it is to be considered.
Fundamental right of accused, which article you were,
Article 22, Clause 2 of the Indian Constitution.
what it says?
It says that every person who is arrested and detained in the custody shall be produced before the nearest magistrate within the period of 24 hours. But in this case, Your Lordship, the accused was arrested on 14th August 2024 and produced before the local judicial magistrate in the evening of 16th August 2024. So in this way, his fundamental right was violated. And it's not only about the conviction of the accused, but also about his the procedural laws that were violated, and the trial was unlawful in this way that the procedures were not followed according to the procedure established by the law.
You haven't answered to the sir that though the procedure has not been followed, whether the trial is been vitiated. That is the main questions.
The trial was unlawful, Your Lordship. With your permission, Your Lordship, I shall begin with the prayer.
Yeah, please.
Wherefore, in the light of the arguments advanced, the appellant most humbly prays before this honourable court that it may be pleased to hold that the appeal is maintainable before this honourable court, declare that the trial in absentia was conducted in violation of the due process and constitutional safeguards, rendering the conviction void ab initio, purge the conviction under section 376 of IPC and set aside the sentence of life imprisonment, declare that the extension of police remand was unlawful and in violation of fundamental rights, thereby invalidating the evidence obtained therefrom, grant such other and further relief as may be deemed just, equitable and necessary in the interest of justice, all of which is most humbly prayed counsel for the appellant.
Yes, please. Yes, respondent.
I request the respondent team 24 to continue with their submission.
24.
Your counsel number 1 or 2? Counsel number 1.
May it please your honor, the council seek permission. The council is appearing before the Honorable High Court in the matter of Rajesh versus State of Aryapur on behalf of respondent side in response to an appeal filed under section 415 of INSS. If your lordship is well versed with the facts of the case, with the due permission of Honorable Court, I would like to proceed with the pleadings on the issue provided.
We have to appreciate even how you appreciate facts. So just narrate the facts in a nutshell.
Yes. Facts of the case were such. appellant and respondent were working together. Gradually, they developed love relationship, and they started living in a house purchased by them jointly. After some time, there were quarrels between them. There were disputes between them. But gradually they also resolved that disputes, and finally on 1st of December they had a sexual intercourse, but on the false promise of marriage. Similarly, after some time the appellant refused to marry with her. He also provided various reasons for not marrying with her, and therefore on that basis respondent filed a FIR against appellant on the rape charges under section 375 of IPC. With the permission of honorable court, the co-counsel would be presenting on first and second issue. Much obliged.
Yes, please. Your speaker number 2.
Yes.
Okay.
Your Lordship, with your due permission, I would like to proceed with the pleadings regarding the issue number 1, that is the appeal is not maintainable before the Honorable High Court.
Yes, please.
Much obliged. On which the council will be establishing 2 grounds. Firstly, the decisions of the Sessions Court should be held reliable. The appeal is not maintainable before the Honorable High Court regarding the conviction order passed by the Sessions Court is in due process of law. Regarding which I would, with the due permission of your Lordship, I would like to give reference of a recent declaration made by Honorable Supreme Court. Supreme Court bench comprising Justice Sandeep Mehta and P.B. Varale, in which they have reaffirmed a well-established legal principle regarding the rape cases, that if the statement of prosecutress is if it inspires the confidence, and if the testimony given by prosecutrix is totally trustworthy and reliable, then it is sufficient on its own to restrain any of the conviction. And regarding the present case, this legal principle is also held reliable. Secondly, I would like to give reference of the case Mahendra Singh versus State of Rajasthan, in which Supreme Court held that the criminal appeal of if the person is absconding, then his criminal appeal should not be held on merit basis. Leniency shows towards the criminals is a threat to the innocent persons. And as in this present case, the appellant was also absconding from the legal procedures, and therefore he should no leniency should be shown towards him. With the due permission of your Lordship, I would like to give proceed with the issue number 2, that is the trial held in absentia was adhered to due process of law, on which the council would be establishing 4 grounds. Firstly, the declared as a proclaimed offender. As mentioned under section 84 of INSS, when 2 consecutive warrants are issued against a person, and if he fails to appear before the court, then he should be declared as a proclaimed offender. And this legal procedure was duly followed by the lower courts and also police officers, and therefore the trial held in his absentia was according to due process of law. Secondly, the trial and judgment held in absentia it was also according to due process of law. As under section 356 of INSS, when a person is declared as a proclaimed offender, then the magistrate, in the interest of justice, can continue the process as if he is present in the court. And with reference of this, I would like to give reference of a case law, H. Arun Bhasha versus State. In this, Madras High Court held that if the accused is absconding, then this is the major issue for dependency of matters in the court. It also violates the right of speedy trial of the respondent. Regarding issue of warrants, as required under section 356 of INSS, 2 consecutive warrants were issued against the accused. Therefore, it is also according to due procedure of law. By concluding the 3 points, I would like to tell the essentials which are mentioned under under section 356 of INSS, that are the accused should be the proclaimed offender, accused should be absconded to evade the trial, and there must be no immediate prospect of his arrest. And in this present case, the accused was satisfying all the 3 essentials
which are mentioned under Article 356 of INSS. Therefore, the proceedings which were held in his absency were according to due procedure of law. Yes, sir. 2 consecutive warrants should be issued against accused.
What more is required? For declaration as absconding accused, except the issuance of 2 consecutive warrants within 30 days. What more is required?
If he is evading from the legal procedures and he is trying to avoid the legal procedures,
Something more is required. Care has been taken to see that person should be given an opportunity to represent himself properly. Therefore, procedure is that his declaration, proclamation should be widely published in the newspaper. Secondly, the declaration should be affixed at the house. Then his close relative or friend should be informed that trial is going to be against the accused. If all these formalities are complete, then and only it will be a case of trial in absentia. Then again procedure is provided that it should be given legal assistance by the state itself from the legal aid, and every attempt has to be made by the judge who is dealing with the trial to give sufficient opportunity of hearing.
yes, in the
So only declaration of warrant, as my learned brother has asked, only declaration of warrant, does it mean that entire procedure is followed under section 356?
only declaration of warrants, but all the procedure which is mentioned was also followed under this. He was voluntarily waived on his right to be present before the court. He was given he was issued with the warrants. Still, he waived on his right to be to prove himself innocent.
Yeah, next.
Now, with the due permission of your lordship, the co-counsel would be dealing with the further issue number 3, 4 and 5.
Continue.
May it please your honor, the council seek permission to deal with the issue number 3rd, that is the lower court's application of substantive and procedural law was appropriate, on which council would be establishing 3 grounds. Firstly, fair application of procedural law. As required under section 84 of INSS, when a person is evading or absconding from the fair trials, he shall be declared as a proclaimed offender. And also under section 356 of INSS, it is provided that when a person is declared as proclaimed offender, trial in his absentia is valid, because the fair chance for representing him before the court was given, but still if he is not appearing before the court, trial in absentia was appropriate, and therefore the lower courts has also applied section 356 and 84 of INSS. Secondly, fair application of substantive law. Substantive law under section 375 of IPC, it defines rape, that when a man had a sexual intercourse with a woman without her consent, it is called as rape. So as the action of appellant will fall under this section, because the consent given by the respondent was not a free consent, as it is required under section 90 of IPC, that the consent shall be free from any misconception of fact, it shall be free from the fear of death or injury. As the consent was given under deception, therefore the consent is not a valid consent, and the charges are rightly framed under the substantive law. Lastly, the police remand was also as per the procedural law. It is provided under section 187 of INSS that when the police investigation can be extended up to 90 days when the offence is punishable with death, life imprisonment or imprisonment of more than 10 years. As the charges framed against appellant falls under this section, the police remand was extended and it was not exceeding to the 90 days. So the due procedure was followed, which is provided under INSS itself. With the due permission of Honorable High Court, I would like to deal with the issue number 4, that is,
As far as remand is concerned, you just argued that police custody remand up to 90 days is permissible under the BNSS.
Yes.
Where is that?
under section 187 of INSS.
Explain.
May I refer to the bare
Yes,
act,
yes,
please?
yes. If that is so, it will be autocracy of the police department.
Under section 187, subclause 3, the magistrate may authorize the detention of accused person beyond the period of 15 days if he is satisfied that adequate ground exists for doing so, but no magistrate shall authorize the detention.
That is important. No magistrate.
It shall not exceed to 90 days. But as police remand was there, that is of 90 days itself. It was not exceeding to 90 days, so it was according to the procedural law.
Yes, please.
With the permission of Honorable High Court, I would like to proceed with the issue number 3rd, much obliged. That is, the rape charges were correctly applied. Firstly, the consent under section 375 of IPC. The consent under section 375 defines that, section 375 defines that when a man had a sexual intercourse with a woman without her consent, it falls under the offence of rape, as the consent shall be free, it shall be free from misconception of fact, and therefore, as the respondent has never given a consent by her own will, it was given under the deception which was caused by the appellant by falsely promising to marry with her. So therefore, the consent was not free, and the sexual intercourse can rightly fall under the definition of 375 of IPC. Secondly, the consent on false promise of marriage. When a man promises a woman to marry for her having a sexual intercourse with her and without any intention of marrying with the woman, it will definitely fall under the definition of rape, as the learned counsel had declared that he had a genuine intentions of marrying with respondent. But I would like to present that he showed his intention in the beginning, but later on, after satisfying his want of having a sexual intercourse with the woman, he withdrew all the savings. He also sold out the house purchased by them. So it had shown clearly that only for obtaining the consent for the sexual intercourse, he had shown the intentions, but he only shown a merely intention, but he never had a genuine intention of marrying with her. Because as soon as his want is satisfied of having a sexual intercourse, he withdrew all the wedding savings, and also he sold out the house purchased by them. In this regard, I would like to give a reference of a case decided by the Bombay High Court in the case of Roopchand, son of Dilip Shende versus State of Maharashtra, where Honorable Bombay High Court held that a promise of marriage to deceive someone into sexual relation vitiates the consent. Meaning that the sexual activity is not a consensual, as it is declared under this case itself that whenever a consent is given under deception, it is as good as no consent, and therefore without a consent, a sexual intercourse definitely falls under section 375 of IPC. With the due permission of Honorable High Court, I would like to proceed with the 5th issue.
Please.
Much obliged. That is, extension of police remand is not in violation of constitutional protection, on which the council would be presenting 2 grounds. Firstly, application for police remand, as it was preliminary charges were framed against the appellant under section 69 of INS, but as this offence is punishable with 10 years of imprisonment and more. Therefore, the 24 hours of investigation is not sufficient, because this matter concerns a privacy. It is a severe offence which is framed on the appellant, and therefore in this regard the police remand was necessary, and therefore the police officers has filed for the application of police remand. Secondly, the extension of police remand, as police remand was granted by the trial courts and lower courts, that is because the matter such like rape, it involves a privacy, it is severe offence, also the sensitivity, looking into the matter of sensitivity, it was necessary for having a extension of police remand in order to make comprehensive investigation. If hasty investigation would have made within the time limit, within a very short period of time, it would have even gone against the interest of appellant itself. and therefore the extension of police remand was necessary. It was in the interest of justice for both the parties.
How you will come out of violation of Article 22, subclause 2? Because any person may be offender under the provisions of such law for which there is death penalty provided. Still he has to be produced before the magistrate of nearest magistrate within 24 hours.
Yes.
It is case wherein he was produced after second day.
Yeah. On 14th
That is violation of Article 22 2.
no,
Even
it
section
was,
57 is violated of BNSS.
it was not in violation of article and also the section, as on 14th of August he was detained. But as concerning with the 15th of August, there is a national holiday. So the court, we cannot produce accused before a court, and therefore he was presented on 16th of August. That was, the police had tried their best for presenting the accused before the court within 24 hours.
By every court there is one court who used to be in the station for taking the custody matters, remand matters. There can't be holiday for the judges, at least for custody matters. Even on the national holiday, 15th August, 26th January, court always remain present for taking the custody matters.
I beg your pardon.
So that point will not appeal. Only because there was holiday on 15th of August, on the eve of Independence Day, court was not available.
I beg your pardon, your lordship. I was not aware of that.
Yeah. Yes.
With the permission of Honorable High Court, I would like to present the prayer in the conclusion of proceedings. That is, it is most humbly prayer that this Honorable High Court, that it may be pleased to dismiss the present appeal maintained before the Honorable High Court, to uphold the conviction which is passed by the Session Court, to uphold the rape charges against the person. The court, being satisfied, may also make any such order as it may deem fit in the light of justice, equity and good conscience.
So it is in the court. You have, in court it is available, your right of response. But in moot court competition that is not there.
We appreciate if you'll reach in another round, make sure that you'll submit this points. Yeah.
Once you have missed the bus, you have missed the bus. Raudra.
I request the appellant, team code number 22, to kindly proceed with their submissions.
point there. So which is team number, team code 22? So you have to come to this side.
You have provided only one copy. Just ask them. Only one copy or they have another 2 copies of it.
Yes.
Yours is team number?
My lord, my team code is 22, petitioner. I will be deal with the statement of jurisdiction and statement of facts and statement of issues, and my co-counsel will deal with the remaining issues.
Your team
Couns-
number 22, speaker number
Speaker number 21.
1. Yeah.
Counsel seeks permission to proceed with the statement of jurisdiction.
Please.
Much obliged. Statement of jurisdiction fill in a High Court appeal. It concerned those the case was Rajesh convicted under the section 376 of IPC, sentenced to life imprisonment, and following trial held in absence of Rajesh. The appeal argues that the High Court has a jurisdiction under section 415 of INSS 2023 to appeal against the conviction. It further contains that Rajesh trial is in absentia. After has been declared he is a proclaimed offender was illegal and challenges the extension of police remand as a judicial overreach. Counsel seeks permission to proceed with statement of facts.
Please.
Much obliged. The plaintiff Ria was an engineer, met Rajesh on a social event on 15th May 2023. Impressed by her work, Rajesh offered her position in his tech startup. After this, they developed a close relationship and began cohabiting. Both are planned to marry and contribute to wedding savings. And in October 2023, they purchased a house on Rajesh's name and sharing the loan repayment. On November 20, 2023, Rajesh physically assaulted Ria and December 1st, 2023, he was proposed to Ria for a marriage, and by mid of 2024, under the parental pressure, he was sought a marriage with another woman. On June 2, 2024, without informing Ria, he withdrew the saving amount with the another joint account with Maya. On July 2024, during the business trip, he was decided to end this relationship with Ria, and he informed Ria that his parents arranged his marriage with Maya. Feeling betrayed and deceived on August 1st, 2024, Ria filed a FIR accusing Rajesh of rape, domestic violence and exploitation under the false pretenses. Rajesh was arrested on 14th August 2024 under section 69 of the INS and allegedly subject to the police torture to extract the confession. He was presented before the judicial magistrate on 16th August 2024. Police custody granted until August 30, 2024. It will repeated extension without proper justification, which is violation of legal safeguard against prolonged detention. On November 16, Rajesh received default bail due to the police failing to fill a charge sheet on time. After completing investigation, the police filed the charge sheet under section 375 and 376 of the INS when Rajesh did not appear after being summoned. Following Rajesh disappearance and unsuccessful attempt to execute the warrant, the court declared him a proclaimed offender under the INSS 2023. The case moved to the Sessions Court. The trial conducted in his absence. Rajesh was convicted in February 2025 under Section 376 and received a life imprisonment. Counsel seeks permission to proceed with statement of issues. Issue number.
Which issues you are going to answer?
Sir,
Issue number, which issues you are going to answer?
I am only deal with statement of issue. My co-counsel will deal with further issues, advance argument.
Okay.
Counsel seeks permission to proceed with statement of issues.
Yes, please.
Much obliged. My lord, first issue raised before the honorable court is the appeal maintainable before the High Court? Second issue, dead trial in absentia other the due process. Third issue is raised before the High Court, raised before the honorable court. Was the lower court application of substantive and procedural laws appropriated? And the fourth issue raised before the court, was the rape charges correctly applied? Fifth issue is, was the repeated extension of police remand lawful consideration constitutional prosecution?
Please.
Counsel seeks permission to skip summary arguments and directly proceed with advance arguments. Much obliged. The first issue raised before this honorable court is the appeal maintainable before the High Court. My lord, the right to appeal is a fundamental legal right of every accused. Under Section 374, subclause 2 of Indus Penal Code, the Rajesh was convicted under Section 376 in lower courts, and in case of State of Haryana versus Bhajan Lal, AIR 604 is cited as a reference emphasizing that accused has a fundamental right to appeal in procedural irregularities or unlawful detention are involved. My lord, in this case, the basic principle of justice, like audio alteram partem, is violated. Natural justice mandates a fair opportunity to an accused to present their case or to defend their case. But in this case, they got no opportunity for the present or defend their case. There raises question about due process, particularly if the accused was not given an opportunity to defend themselves. In Maneka Gandhi versus Union of Indusland 1978, and also in Zahira Habibullah Sheikh versus State of Gujarat, reinforces that a fair procedure is essential under Article 21 of Constitution, and the trial without a fair opportunity for an accused is a miscarriage of justice. And in this case, Rajesh violates their the lower court violates fundamental rights of Rajesh. My lord, one question is arised here. After obtaining a default bail, especially whether accused is intentionally evaded the law or was forced to flee due to the police remand. Because in this case, the police tortured Rajesh during their remand time. Also in case of Jian Singh versus State of Punjab 2012, the Supreme Court held that even an absconding accused has a right to defend themselves before conviction. And also in trial in absentia, if the accused is not present during the trial, it can be deemed unfair. And in this case, the confession obtained through a torture violated Article 20, subclause 3 of Indian Constitution, which protects against the self-incrimination. Hence, the court should not consider confession comes in PCR because the settled principle of Indus Land Saksha Adhiniyaman under Section 24, 25 and 26. In case of Nandini Satpathy versus P.L. Dani in the year of 1978, the Supreme Court established that the forced confession is a violation of a constitutional protections, and in case of Kattar Singh versus State of Punjab 1994, the court emphasized that the necessity of legal justification of prolonged police detention. The second issue raised before this honorable court, right to fair trial and due process under the law. The Supreme Court in Maneka Gandhi versus Union of Indus Land in the year of 1978 emphasized that procedure established by law must be fair, just and reasonable. A trial in absentia should be conducted in strict adherence to legal procedure, ensuring that the accused is given a fair chance to defend themselves. And legality of Rojas as a proclaimed offender, my lord, trial in absentia, the procedure is not followed according to section 356 subclause 7, because police notices section 84 and 85 of INSS outline the procedure for the declaring a person proclaimed offender, issuance of summons and warrants. Second, public declaration of accused as an absconder offender. Third, the sufficient time and effort to secure the accused presence. In this third issue, the court first summons issued on 1st of December 2024, and section 356 subclause 7 stated that the court must be ensured that 2 consecutive arrest warrants have been issued within an interval of at least 13 days. But here the period of it's only 28 days. So it's not followed a dual procedure in this case. Also in D.K. Basu versus State of Bengal 1997, the Supreme Court held that custodial torture violates constitutional rights and confession obtained through coercion is inadmissible. The third issue raised before this honorable court, the application of substantive and procedural laws appropriate. Under section 187 of INSS, the accused cannot be detained beyond 15 days in police custody. However, in this case, Rojas continuously placed under remand until 14th of November 2024, violating the procedure limits on detention. And also one question is there. Rojas was arrested. FIR was filed at 1 August 2024. Rojas was police got remand on 14th of August, and within 24 hours we can present the accused before magistrate. But in this case there are 48 hours are included. What about the next 24 hours? Illegal trial in absentia. In case of K.S. Panduranga versus State of Karnataka in the year of 2023, the court that trials in absentia should be last resort, used only when the accused is deliberately avoiding the trial. In this case, the authorities should not have ensured Rojas' presence before the pronouncing judgment. The wrongful conviction based on procedural lapses. The burden of proof made under section 101 of ISA, the prosecution must prove guilt beyond reasonable doubt. Here the evidence was based on illegal confession, vague allegations and procedural lapses. Misapplication of rape law. State of Karnataka versus Krishnappa in the year of 2000 held that rape convictions require clear evidence of force, fraud or lack of consent. In this case, Ria consented to relationship believing in marriage, which is a matter of broken trust, not rape. Fourth issue raised before this honorable court was the charge of rape correctly applied. My lord, Rojas got the first thing is Ria consent is valid consent. Here is no direct evidence that Rogers has a malified intention from the beginning. In this case, please look on submission.
Page number.
One is just one only page I had submitted. With highlighted part. In case of Uday v. State of Karnataka 2003, the Supreme Court ruled that if a woman was aware of the risk of relationship and still consented, her consent remains legally valid. Thus, her consent was voluntarily valid under Section 19 IPC, meaning the charge of rape does not hold. And the promise of marriage was genuine, but circumstances changed. Change of circumstances is not same as fraud. Rogers did propose marriage and started plan for it, proving that his initial intent was genuine. His parents' opposition and financial issues influenced his decision to withdraw his commitment, which is not a crime. Courts have ruled that if a promise is broken to later circumstances, it's not a cause of false promise leading to rape. The last issue raised before this honorable court was the repeated extension of police remand lawful considering constitutional protections. My lord, the prolonged and cyclic extension of police remand violates Article 21 of accused Rogers, which guarantees no person shall be deprived of life, personal liberty except according to procedure established by law. Also, Article 22 of Indus-Land of Constitution of safeguards to an accused, ensuring that police custody is strictly regulated. The police cannot detain an accused indefinitely without a charge sheet, as it violates the principle of due process. And also the custodial torture and violation of a fair trial principle. Article 20 and Article 21 of Indus-Land of Constitution, no accused can be forced to confess under police torture. The reports indicates that the police used coercion and torture to extract the confession, making it inadmissible under Section 29 of the Indus-Land Saksha Adhiniyaman 2023, equivalent to Section 24 of Indian Evidence Act. Council seeks permission to conclude my prayer.
You don't want us
It
to
is-
ask
it
any
is-
questions?
Yes.
It is your case. You are trying to impress upon us that the conviction is based on the alleged custodial statements. Okay? The statement which is given by the accused during the course of police custody is not admissible. That is extrajudicial confession. That cannot be accepted, and even conviction cannot be based on that. And it is not your case that the entire case, we have gone through the case, nowhere it is stated that the conviction is solely based on the alleged statement given in the police custody.
Your entire argument was based on that
That
particular
aspect
point.
only.
Yeah.
And facts are totally silent on that aspect. And even statement made to the police, forget about admissibility, even that cannot be proved in any manner. It cannot be read in evidence, because that is confession beyond the jurisdiction of the court. It is outside the jurisdiction of the court. So it is, therefore it is called extrajudicial confession, and that is not admissible. So there cannot be conviction on that aspect.
But he was convicted on the charge of rape 376.
Yes, so there must be some evidence that lady must have been examined by the court. She must have been entered in the witness box. She must have given statement in consonance with the FIR which he has filed. So unless that is there, session court will not convict in such a way, only on the basis of alleged extraction of statement in the police custody.
And you yourself has admitted that her consent was a valid consent. How you justify that, whether the consent was not under deception?
Because there is no evidence of any force, fraudulent behavior.
Whether direct evidence is required. Court can gather.
Court has to infer.
Ah,
Court has to
sir.
infer. And there is more likelihood of this consent taken by a deceitful mean on the pretext of you were withdrawing the entire amount and selling the house which was purchased from the share of Ria. So that supports the case of prosecution that there was deceitful intention from the beginning.
And the court has appreciated your conduct.
Uh,
Have you referred section 69 of BNS? Have you referred section 69?
That is new provision. It was not in IPC. It is introduced in BNS only.
Yeah, you can put your prayers, please.
Time after that.
झालं.
In light of arguments and legal precedents, Rojes respectfully praised that Honorable High Court set aside a conviction and sentence imposed by learned trial court, and prosecution has failed to establish the charges beyond a reasonable doubt, declare the remand proceedings and the trial in absentia as vitiated due to procedural irregularities and violation of the appellant's right to fair trial, grant any other relief as this honorable court deems not proper in the interest of justice, and for this act of kindness the appellant shall ever pay.
Thank you.
Thank you.
Yes, please.
I request the respondent team 17 to proceed with the arguments.
Respondent submission is not given. Respondent submission. Their submissions. एकच copy. Only one copy. नाही त्यांचे फक्त जजमेंट्स आहेत. हां.
That may be
एक
there.
आहे. Please.
May it please this honorable court, I along with my co-counsel have the honor to appear before this honorable court on behalf of the respondent. If it please the honorable court, I shall now humbly present a brief summary of the facts.
Your speaker number?
Team number 7.
Speaker number 1 or
Speaker
2?
number 1. Much obliged. Rojesh and Ria developed a relationship, lived together, plan no more, resulting in his promise of marriage. Ria agreed to sexual relationship with him in December 2023. By May 2023, by May 2024, Rojesh became a by May 2024, Rojesh became distant, withdraw their wedding savings. Thereafter, fund to move later ended the relationship. Feeling deceived, Riaz filed a FIR against him for rape, domestic violence, exploitations under rape presence. Court charged under section 375, read with 376 IPC. Rojesh was declared a proclaimed offender and was tried in absentia, resulting to life imprisonment. Rojesh's lawyer Rojesh has challenged the trial, remand the prosecution, procession and conviction before the High Court. With the kind permission of this honorable court, I shall now proceed the statement of issues involved in the matter before this honorable court. Much obliged. The first issue is the appeal maintainable before the High Court. Second issue is did the trial absentia adhere due process. Third issue was the lower court's application of substantive and procedural laws appropriate. Fourth issue was the charge rape collectively applied, and fifth issue was the repeated extension of police remand lawful considering constitutional protections. If the honorable court permits, may I start with the first issue? Much obliged. Issue number 1 is the appeal maintainable before the High Court. Appeal is not maintainable under section 356 of INSS 2023. Section 356
subsection 7 of INS provides no appeal shall against the judgment under this section unless the proclaimed offender present himself before the court of appeal. In this case, Rajesh was declared a proclaimed offender, and for the appeal he is not present in the court. He appealed through his advocate. And violation of clean hand doctrine. The clean hand doctrine is equitable principle stating that parties seeking relief in the court must have acted fairly and honestly regarding to subject matter their claim, meaning they must come to court with clean hands. The Rajesh comes before the court with unclean hands, having absconded to evade trial. Court generally do grant relief to litigant who deliberately avoids the legal process. The principle that fugitive from justice cannot seek legal remedy applies here. The Rajesh voluntarily absconded despite due legal procedures, public policy and judicial efficiency considerations. If the High Court allows to appeal while Rajesh remains absconding, it would set a dangerous precedent, encouraging accused person to flee and later challenge their convictions. The judicial system cannot reward an individual who disrespects the authority of the court by failing appear to them seeks relief. Accepting the appeal would encourage delay tactics undermining public confidence in the criminal justice system. If the Honorable Court is satisfied with the first issue, may I proceed with issue number 2? Much obliged. Did the trial absentia adhere due process? Trial in absentia was lawful under section 356 of INSS. Section 356 subsection 1 of INSS says a proclaimed offender absconded to a trial and there is no immediate prospect to arresting them, certain consequences follow. Such an absconding person deemed to have waived their right to present and tried in person. The court, after recording reasons in writing, can proceed with the trial as the absconding person present, ensuring that justice is not delayed due to the accused absence, that the court can deliver judgment in the case even if proclaimed offender is not physically present. In this case, INS Dontavi explicitly permits trial in absentia when accused deliberately absconded despite being given ample opportunity to before the court. So this case procedure of trial absentia correctly applied. 356 of 6 INSS 2023. Once the trial has started, the accused will deliberately absent themselves, the court can continue proceedings. The trial can proceed even in their absence, including the pronouncement of judgment. If the accused returns or arrested at the conclusion of the trial, judgment remains valid, trial does not be restarted. If the Honorable Court is satisfied with the issue number 2, may I now hand over the dais to my co-counsel, who shall presenting the submission on issue number 3 before this Honorable
One question for you.
Yes, sir.
How doctrine of clean hands will apply in criminal law?
Sir, in this case, Rajesh before the court, unclean hands.
How? He was declared absconding. Rightly, wrongly, he was convicted. He has right of appeal before the High Court under 415.
Yes.
He approached the High Court by filing appeal. Where is question of unclean hands?
Sir,
And
it's-
only because he presented the appeal through his advocate.
Yes, sir.
Can you say that appeal was not maintainable or this appeal is not maintainable?
Sir, section 356(7) of INS.
Only his absence before the court can take away his statutory right to file appeal.
Appeal is statutory right, but according to sir, section 356(7) says a proclaimed offender cannot appeal against the judgment unless they first present before the appellate court.
How you can read that section, subsection 7 of 356 as mandatory?
Yes, sir. Mandatory.
Can it be read as mandatory?
Yes, sir. This is mandatory
How?
because in this section says proclaimed offender not present before the appellate court.
He has represented appeal through advocate. Na?
No, sir. Through advocate there is no right to appeal. There in this section correctly says a proclaimed offender cannot appeal against the judgment unless the first present themselves in the appellate court.
please this honorable court, I shall now present the further issues. If the honorable court satisfied with issue number 2, may I proceed with issue number 3?
Yes.
Much obliged. Issue number 3 is was the lower court application of substantive and procedural laws appropriate? The proper application of substantive laws. Indus-Land Penal Code and governs the offence rape under section 375, read with section 376. The lower court correctly applied the law, recognizes the fraudulent inducement to consent, can voided consent, making the case rape under IPC 1860. Ria consent was based on Roger's explicit promise of marriage, which he later unanimously retracted while entering into relationship with another woman. Court have upheld the misrepresentation leading to the consent constituted sexual assault. At the time of crime happened, there is a IPC in force. So the lower court applied charges of 376 is appropriate according to rape punishment. Absconding justified trial in absentia. Under section 356(1) of INSS 2023, after the following requisite procedure, court started the trial in absentia. When Rojesh, the court courts issued summons and 2 consecutive warrants, the Rojesh is not present at trial, so court declared that Rojesh is as proclaimed offender. So according to this section 356, the proclaimed offender who is not present for trial, he waives their rights of trial and presentation to court. So court can give the judgments if proclaimed offender is not present in court. Since Rojesh is evaded proceeding willfully, the trial was conducted in accordance with INSS 2023, which allows trial in absentia for proclaimed offender. Summons, arrest warrants and public notice were issued proving that procedural safeguards were met. If honorable court satisfied with issue number 3, may I proceed with issue number 4? Much obliged. Issue number 4 was the charge of rape correctly applied. Consent was given not voluntarily. In case Holman versus R, you can refer in submissions. The court held that consent does not always mean the complete willingness of woman for sexual intercourse. Sometimes the consent of woman may be hesitant and reluctant. Ria gave consent to Rojesh for sexual intercourse because she was not losing the Rojesh because she loves him. In case of State of UP versus Naushad 2013, the Supreme Court found that the consent obtained by accused was not voluntary, which was given by prosecutor under the misconception of facts that accused would marry her. So the court held accused guilty of rape under section 376 of IPC 1860. In this case, Naushad take consent that victim to by promise of marriage, but he not marry. So the court held that the consent was given involuntarily. So court held guilty to accused. Violation of Article 21 of Constitution of Indus-Land 1949. The Article 21 of Constitution of Indus-Land says no person shall be deprived of his life and personal liberty except according to procedure established by law. Rape being a violent act that infringe upon person bodily autonomy and dignity is considered as a violation of fundamental rights. Rape is considered as a violation of person's fundamental right to lie the personal liberty which was guaranteed under Article 21 of Constitution of Indus-Land 1949. It is the most normally and physically abhorrent crime in society since it violates the victim's body, mind and privacy. Article 21 provides crucial safeguard for individuals ensuring that they are not arbitrarily deprived of their life and liberty, and a legal proceeding related to section 376 of IPC are concluded fairly and justly. Rape is a crime which is not related with only person, it is related to society. Its effects affects the society as well as. So Article 20, the violation of Article 21 is the violation of Article 29 happens in this case. Malified intention of the context of promise of marriage. Malified promise means making promise with deceptive motive, where the person making the promise never intended to fulfill it, but rather used to deceive the other person. Rajesh already engaged with Maya. The Riya saw Rajesh conversing with Maya at restaurant. After argument brushed between them, Riya and during argument, Rajesh slapped Riya. If any person loves someone or don't have malified intention, he never harm a person whom he love in public. After that, Rajesh promises and he started sexual intercourse. In May, Riya noticed the changes in Rajesh's behavior. On June, Rajesh withdraws all savings without informing Riya from their joint account, which was they planned for marriages. Riya discovered the fund transferred to Rajesh with Maya. In July, Rajesh ended the relationship, as well as Rajesh sold joint property of Maya and Rajesh, which are they bound. So the malified intention of Rajesh is from started only for lust. Rajesh had promised to marry for sexual intercourse. In case Dhamura Muridhara Sonar was the state of Maharashtra, court such cases must veritably examine it that complainant had actually wanted to marry victim or had malified intention. If the complainant had any malified intention or any deceptive motives, it's clear case of rape. According to Indus Land Penal Code 1860, there is no special provision for false promise of marriage, which is not amounted to rape. The charges of rape convicted on Rajesh is appropriate with respect to IPC because consent obtained was malified. The conviction was procured under section 376, which means the charge of rape applied correctly as per substantive law, which was enforced in during crime. In new laws, BNS, section 69 was introduced. In that section, there is a provision for false promise, but in IPC time, there is no provision for false promise about rape. If the Honorable Court satisfied with issue number 4, may I proceed with issue number 5?
One question for you. Initially, case was registered under section 69 of BNS.
Yes.
BNS.
हाँ.
Trial, while during the course of investigation, you altered the charge. Investigation officer submitted charge sheet under section 375.
हाँ.
Trial concluded under section 375 and punished under section 376. When the offences were punishable under Indian Penal Code, getting my point, how trial is permissible under the BNSS? Because section 4 of BNSS specifically says that all the offences punishable under BNS or any other offences for time being in force will be tried under the new act. Whereas section 4 of IPC says that CRPC says that all the offences punishable under provisions of Indian Penal Code, those must be tried under CRPC. So this trial is under BNSS, that is faulty trial.
Section 531 of BNSS states that the section 531 of BNSS repeal and means the crime happened in IPC era or CRPC era. The charges on the accused is as per substantive laws, but the procedure for trial is based on new laws introduced as BNSS.
Which section?
531.
531. No.
If the
read section 2, section 538, subsection 2, clause A.
Sorry?
Subsection 2A of 531 of BNSS.
The same section which you have referred.
Yeah.
Sir, 531 all just 1A.
It is against you.
Huh?
It is against you.
Ag-
It is against the prosecution.
No.
Read section.
So pardon, I forget where act.
Section 350, 531. Yeah, so the clause number 2 is against you. So the (531) subsection 2.
ठीक है.
Procedural laws are
So how you can justify this trial?
So,
In the wake of the fact that offence was leveled under IPC and trial was conducted under BNSS,
so the procedural
when
laws,
CRPC was applicable for that offence.
so the procedural laws are retrospective.
You can conclude by prayers.
In light of argument and legal precedents presented in the respondent humbly prays that this honorable court may be pleased to dismiss the appeal filed by appellate as it lacks the merit and is unsustainable in law, uphold the conviction and sentences awarded by the trial as it was based on proper application of substantive and procedural laws, and the guilty of the accuser was established beyond the reasonable doubt, declared that trial in absentia was lawful considering the appellate willfully absconded despite multiple summons and warrants, thereby forfeiting his right to be present, hold the repeated extension of police remand where justifies the lawful as we granted the competent court under section 187(3) INSS 2023 based on the necessity of the investigation, hold the absconding reinforced guilt and the appellant's flight from justice further corroborative the correctness of his conviction, pass in order that this honorable court may deem fit in the interest of justice, equity and good consequences. Much obliged.
All rise.
Take it, bas.